But assuming that we won't forget whatever I wanted, because that's another danger. If it takes long, things can disappear from the folder. so we can proceed.
Thank you, Chair and honorable members. We'll proceed now to look at the explanatory memorandum on the National Prosecutions Authority Amendment Bill number 7 of 2023. Chair and honorable members, by way of background, this bill seeks to amend the National Prosecutions Authority Act number 34 of 2010 so as to revise the composition of the board and provides for its functions and matters connected with or incidental to the foregoing. Currently, Chair and honorable members, the composition of the National Prosecution Authority Board consists a majority of civil servants. This composition is, however, contradictory to tenets of good corporate governance. Therefore, the bill, once enacted, will ensure diversity in the composition of the board and lead to the authority complying with the principles of good corporate governance as well as conforming to international best practices in board member selection. Specific clauses of the bill, Chair, will start with clause 1, which provides for the citation of the act once enacted. Chair, clause 2 seeks to amend section 2 of the Principal Act by deleting the word secretary and by inserting new definition in appropriate places. The amendment to the interpretation section will provide definitions for key phrases in the Act once amended. That will make the law easier to understand by the citizens and those mandated to implement it. Chair, we move on to clause 3 of the bill. This bill is a repeal and replacement of section 7 of the Principal Act by revising the composition of the board of the authority in order to streamline the number of civil servants on the board and include more members from the private sector, such as the Legal Aid Board, the Zambia Institute of Human Resource Management, the Zambia Institute of Chartered Accountants, and a civil society organization that provides legal aid services. The clause further sets out the qualifications as a chair for appointment as a chairperson of the board, the manner in which the vice chairperson is to be elected, and the nomination of board members by their respective organization and institutions for appointment by the minister. Lastly, Chair and honorable members, this clause sets out the disqualifications for nomination or appointment of the members of the board. Chair and honorable members, we proceed to look at clause 4, which is an insertion of section 7A. This clause seeks to insert a new section immediately after section 7 that sets out the functions of the board of the authority, which includes approving the policies, programs, and strategies of the authority and promoting the effective corporate governance of the authority. Additionally, Chair and honorable members, the clause seeks to empower the board with authority to delegate any of its functions under the Act to the Director of Public Prosecutions. Chair, the last clause to be considered under this bill is clause 5, which deals with amendment of the first schedule by deleting part 1 and substituting it with a new part in order to revise the provisions relating to the administration of the authority, which include, among others, provisions, tenure of office, and vacancy of members of the board, proceedings of the board, and committees of the board. I submit, Chair.
Yes, we are ready. Yes, Honorable Fuga.
Chair, my first comment is I don't know how Parliament wrote to Minister of Justice and what is expected from Minister of Justice. If you go through these amendments that have been suggested, Minister of Justice has not spoken to anything that we can have maybe take home message, and I think I can demonstrate to that effect. When you look at most of the suggestions that are in this suggested bill for the amendments, And I think we need to start taking the work very seriously, because when you look at the Commission, it deals with the Bill of Rights. And when we talk about the Bill of Rights, we have sat before here, and we have been looking at the African Charter and many other factors, and how we sail on the globe. Maybe just to demonstrate a bit on, I'll go to section 6 of the Human Rights Commission and what they are suggesting. When you look at what has been suggested, there is a barrage of things here that from A to I think K, passing KL, from A to L, if we are to follow the alphabet. But you have seen that the ministry has not spoken to any. And this is the core and the backbone of the Human Rights Commission. But you also realize that what this bill is suggesting is not in tandem with the Constitution. Because when you go to the Constitution, Part 1 of the Constitution, on the supremacy of the Constitution, Article 1, it states, this Constitution is the supreme law of the Republic of Zambia, and any other written law, customary and customary practice that is inconsistent with this provision is void to the extent of the inconsistency. When you go to that, you go and search in the Constitution further, in Article 230. The 230 lines up the functions of the Commission, which this bill seeks to expand up to L. But when you look at that, the ministry, which is the mother ministry and the backbone of lawmaking, has not spoken. They have not given us any opinion as to what they feel about these amendments. All the madam has been doing is a description of what the clause intends to talk about. They have not given us reasons of what is the ministry thinking. What is the ministry thinking about all these amendments? It's bulky. It's more like we are dealing with our clause. Having said that, I want also to ask the Minister of Justice on what they feel about investigation of, because even these amendments have left it hanging. Once these investigations are done and the like, it's like they are going to be left to any other institution, not the Commission, to actually prevail over those violations. So I think I'm at a loss with their presentation, which is just descriptive, not suggestive. I don't know which is the take-home message. To me, I would like to submit that the Minister of Justice did not attend to this work as they are expected. I submit.
Maybe before we proceed to the next observation, I don't know, what is the comment from the Minister of Justice of that observation?
Thank you very much, Chair and honorable members. So in terms of the functions, as we explained earlier, the functions that are contained in the bill are merely a supplement to what is contained in the Constitution. When you look at Article 233F of the Constitution, this provision provides that the Human Rights Commission shall perform such other functions as are prescribed. So the meaning of the term prescribed, which is under the Constitution, is that that particular provision will sit under an act of parliament. And by way of introducing those numerous provisions that are under the bill, Chair and honorable members, were merely complying with what the Constitution says. Then, Chair, the second issue that I noted was what happens when the Human Rights Commission makes a recommendation. What will happen after that? Chair and honorable members, when you look at clause 21.3 of the bill, after the Human Rights Commission makes 21.3 of the bill, so after a Human Rights Commission makes a report or a recommendation to an appropriate authority, that appropriate authority is mandated. And when you look at the provision under subsection 3, it says shall. So that appropriate authority is mandated within 30 days from date of receipt of recommendation under subsection 2 to submit a report to the Commission on any action that is taken by that appropriate authority to redress a human rights violation and abuse. Chair and honorable members, subclause 4 further provides that if that appropriate authority fails to submit a report to the Human Rights Commission on the actions they have taken with regards to the recommendation that came from the Commission, that appropriate authority commits an offense and is liable on conviction to a fine not exceeding 300,000 penalty units. I submit, Chair.
Yes, Honorable Fuga.
Yeah, I still believe that we are still dealing with the skeleton, not the flesh. Why I say so is that, for instance, what she has just addressed, I would give an example. You and I were in Uganda recently, and we are looking at the human rights there. And I think if you look at the suggestions that have been made, I do agree with her when she talks about, though she said 230, but it's 233, but it's 230F specifically, which says perform such other functions as prescribed, which I don't expect that all these things that are in the Act should be in the Constitution. That is not my expectation. But what I expect is that when you look at what has been suggested, it will still be an academic exercise if the Human Rights Commission is not given teeth to bite. That is my argument on this one. And I think I wanted to pick the standing of, as you warned, when we opened, that we should have a proper stance from the Minister of Justice. And I would like to believe that our witness is representing the Minister of Justice. So what is this vacuum? Who fills this vacuum? Because if you look at the functions that have been put in here, they can only entail that the human rights can only be effective, the Human Rights Commission can only be effective if it is the one which is going to implement redress that is coming out of the violations. But it seems that, again, as it may be, it has been pushed to other institutions to address the human rights violation, not the human rights itself. I think that's what it's suggesting. Then, my expectation was that out of all those clauses that she was going through, to me, what she has done is grandstanding and landscaping, not necessarily putting fresh to the issue, because what I expected is, for instance, what is the human rights thought on the section that is as expanded functions? What is the human rights thought on the functions to do with the composition? That is what we expected, but that has not been spoken to. What she did is just read through the clauses and describe to us of what we expect the clause to do, not the fresh. That is my emphasis.
Maybe I want to give a question here. Today is our second meeting, if I can remember very well. The first meeting we had was to introduce to the committee about the two bills. Not so? And from that meeting, the timetable was drawn. And that drawing of the timetable is what has produced today's meeting, beginning today until further notice. So I'm assuming and believing that this is our first meeting. That is one. Two, the bill we are looking at is almost a repeal. And the drafter of this bill is who we are with today. So we are beginning to meet stakeholders who have also received the same proposal, which is resulting into a repeal of the Human Rights Act. So, Minister of Justice presence here from today up to the end of our meetings is to receive, like you are saying, from all the stakeholders who will be appearing before the committees. So today's meeting is just an opening. It's not a closing up that we are sealing the bill, so there's nothing again that we are now opening the bill for public to contribute. So the ministers had, so it will take note. So at the end of our meetings, then we shall know what is to be put in the report. Otherwise, it's not like what you say, casting what? It isn't. Yes, so the ministry and the committee is ready to listen to any other submission according to the clauses outlined in the bill. That's my feeling.
Understood, Chair.
Yes, Honorable Chinkuli.
Thank you, Chair. My contribution is on, I want to look at the clause 10, emoluments of members vis-a-vis impartiality. Many times we want to copy and paste whatever comes from somewhere, but without looking at like, if I may borrow, the meat that needs to be put here. I don't know how you're looking at impartiality versus this clause. The president appoints the commission. So I don't know how you agree with me that that which appoints can disappoint you. And what we are seeing in practice is we tend not to bite the finger that, feeds us. So if a matter comes to the commission, and maybe for some other reasons, the executive, once has an interest in that. So I don't know how the impartiality will come in. Secondly, there's another one is clause 14 and 15. Prohibition of publication or disclosure of information to unauthorized persons vis-a-vis immunity. You are giving the commission to punish whoever discloses information to, but at the end of the day, again, you are isolating the commission from So I don't know how the commission would want the commission to operate. So I think there are some of the issues that I felt they should be looked into. Thank you.
You can comment?
Thank you very much, Chair. I'm going to start with the issue of clause 14 and 15, Chair and honorable members. So when you look at clause 14, obviously the commission under some points, they're mandated to publicize whatever findings they come up with. But then what section 14 is doing is that before any information is publicized, there should be a procedure. If I sit, I'm a member of the commission, we discuss certain things here. I can't just go out there in my individual capacity to publicize that information. I may need to get authority, for example, from the chairperson of the board or committee for me to be able to publish that information. So basically, what this clause is saying is that you can't disclose information to a person who's unauthorized. If you have to disclose that information, there should be a procedure, a channel. Thank you. Yes, so clause 15, Chair and honorable members, basically provides for a situation where I am performing a function of the commission. Then maybe I perform a function that someone is not happy with. For example, my colleague here, Taona, she's not happy with a function that I have performed as a member of the commission. When she's not happy with that function, then she can't go ahead to sue me in my individual capacity. I am performing the functions of the commission as either a member of the commission, a member of the committee of the commission, or a member of staff of the commission. What that person can do instead is sue the commission, because when you look at this bill that we have brought before you, if you notice, one of the major differences that we have made provision for in the Act is under clause 4 of the bill. Under this clause, Chair and honorable members, we have created the Human Rights Commission to be a body corporate with perpetual succession, and they are capable of suing and being sued in its own name. What used to happen before, Chair and honorable members, is that if the Human Rights Commission have a matter, for example, even relating to a dispute with an employee, they'll need to use the Office of the Attorney General for them to be able to sue in that matter. But then with this provision now, the Human Rights Commission, they will be able to do the suits in their own name, and they can be sued in their own name. Conversely, also, if someone is suing the commission and they decide to sue the commission currently the way the bill is, it will mean that that person will need to sue the Attorney General. If they sue the Human Rights Commission currently, we as the Office of the Attorney General will make an application before court to say the Human Rights Commission, they don't have that corporate capacity. So basically, clause 15 of the bill seeks to insulate the individuals, members of the commission, members of the committees of the commission, as well as the members of staff to be sued in their personal capacity whenever they are performing the functions of the commission. I submit here.
Yes.
Sorry, Chair and honorable members, I think there was one person relating to clause 10 with regards to the Emoluments Commission,
Yes,
with
yes.
the issue of impartiality.
Yes.
Chair and honorable members, when you look at the Constitution, sorry, Chair and honorable members, I'm just trying to get the actual article. So when you look at the Constitution, Article 232 of the Constitution, it establishes the Emoluments Commission, which is mandated on the recommendation of the relevant authority or commission to determine the emoluments of public officers. Then when you look at the issue of the relevant authority, you draw that relevant authority from the Gazette notice, which will stipulate under which ministry, or it will basically stipulate the function portfolios of a certain institution. And when you look at the Human Rights Commission, it falls under the office of the president. So the person to make a recommendation to the Emoluments Commission with regards to the emoluments, it will be the president. With regards to impartiality, that is subject to debate. I would agree at some point it will be diluted, but thank you, Chair.
Okay. Yes, Honorable Cassandra.
Thank you, Chair. On page 2, the background, the second paragraph where it is written, the Human Rights Commission Act 1996 is inadequate. So that is my concern. I just want the witness to demonstrate by way of an example how inadequate the 1996 is. That is number one. Just point one in, give examples of the inadequacies, maybe one or two. Okay, and then the second question is on the same paragraph where it says, therefore, there is need to repeal and replace the Act in order to align the Act with the Constitution amended in 2016. I have no issues with the Constitution amended in 2016. I have no issues with the Emolument Commission, but I want also the witness to demonstrate to how the alignment should comply with the United Nations Paris Principle relating to the issues of, at least pick few clauses in that United Nations Paris Principles to say, now this amendment at this juncture, at this clause, is complying to this. That is secondly. Then the third one, it's where you've said on clause 17, where you've said the clause empowers authorized officer at any reasonable time without prior notice and with a warrant to, among other things, enter, search and inspect any premises without prior notice. This is anarchy. This is a Human Rights Commission which should protect my rights, and they should be the ones to just barge into my premises without notice. I have a concern with that clause. Maybe you can give reasons, clause 17. Maybe you can give reasons to this committee why a Human Rights Commission should just barge into my premises without any notice. What are the reasons why the ministry would want to give such powers to the commission that should protect human rights to break human rights themselves? I submit, Chair.
I can respond.
Thank you, Chair and honorable members. So firstly, I think the issue was the first question that was raised relates to the inadequacies that are in the present act. So I think one of the issues is what I had explained earlier with regards to corporate personality. When you look at the current act, the Human Rights Commission did not have corporate personality. What we mean by corporate personality is this institution is capable of suing and being sued in its own name. And I think I had elaborated, Chair, before what challenges they had in terms of suing. And also when you just look at it in terms of independence, for example, the Attorney General, as per the Constitution, is the chief legal advisor to the government. Now it imagines there's an issue where, for example, the Human Rights Commission intends to take to court and it borders on a state institution. How then do you convince the Attorney General to take up that matter in your behalf? So I think by making that particular provision, it's a big milestone, and it has to some extent dealt with one of the inadequacies that the current bill has. The other inadequacy, Chair and honorable members, that was there in this current act relates to the tenure of the members of the commission. So when you look at the act, the tenure for members of the commission was 3 years, subject to renewal. However, when you look at the current bill, the tenure of office of a member of the commission has been limited to 6 years. So previously, you would have a situation where if someone is appointed as a member today, as long as the appointing authorities keeps on, renewing, there's a possibility that someone can serve for such a long time beyond 6 years. But then under the current bill, we have decided to also limit the tenure. Chair and honorable members, one last issue that I would like to highlight, just among the many issues, is the issue relating to appointment of authorized officers. That is another inadequacy that was felt is there in the current act, which this new bill seeks to provide. Chair and honorable members, these authorized officers are intended to make sure that the provisions under the act are complied with, or rather, the appointment of these authorized officers is intended to ensure compliance with the provisions of the act. Chair and honorable members, I'll now move on to the second question that was raised with regards to the Paris Principles, the UN Paris Principles. Chair and honorable members, Paris Principles are principles that sets out the minimum standards that national human rights institutions globally must meet in order for those institutions to be considered credible. And one of the issues that the human rights, one of the principles that falls under the Paris principles is to ensure that a human rights institution has got independence from the government. And again, like we explained earlier, I think for us the issue of corporate personality is one of the elements that ensures that there's some independence of on the Human Rights Commission from the government. In addition, Chair and Honorable Minister, sorry, Chair and Honorable Members, pardon me, Chair. In addition to that, Chair and Honorable Members, one of the standards of the Paris principles is to ensure that a human rights institution has got powers with regards to inquiries, investigation, and the documents that they need to get in order to conduct their investigation, and also collaboration with NGOs and other sectors. When you look at the functions of the Human Rights Commission and the bill, just indulge me, Chair, to open the bill. So when you look at the bill, Chair, on functions, that is clause 6 F of the bill, that provision provides for cooperation with other institutions and organizations which promotes the protection of human rights. So, Chair, in summary, those are what the Paris principles provide for, and how the new bill seeks to make sure that the Paris principles are reflected therein. Chair and honorable members, I'll move to the last question that was raised with regards to clause 14, where an unauthorized officer without prior notice can barge into a place where the authorized officer reasonably believes there's a violation of human rights and freedoms. Chair and honorable members, when you look at that particular provision under clause 15, sorry, clause 17. When you look at that particular provision, Chair and honorable members, it, yes, quite all right, it says it is without prior notice. However, that search can only be done on a warrant, on the power of a warrant, and a warrant is obtained from court. So we assume that to some extent, we believe that that protection will be given by the court, because you will not just go to conduct a search without getting a warrant from the court. And the court, as you are making that application for a warrant, they will determine whether the matter that you have brought before it raises justifiable grounds in order for it to grant a warrant. I submit, Chair and honorable members.
As Honorable Chair.
Thank you, Chair. On page 7, clause 20, where it says the clause further permits the Commission to discontinue or refuse to conduct an investigation where the Commission is satisfied that the complaint or allegation is malicious, frivolous, vexatious, or the particulars of the accompanying the complaint or allegation are insufficient. Here, I feel that there should be some type of appeal process, especially because the Commission is not completely separate from the government. What is your comment on that?
Thank you, Chair and honorable members. So when you look at that particular clause, clause 23, so the Commission, where they decide to discontinue or refuse to conduct an investigation, they are supposed to inform the complainant in writing within 7 days of making that decision. Then, Chair and honorable members, when you look at this bill, we have a provision under clause 30, of the bill, which provides for appeals. So a person who is aggrieved with a decision or a recommendation of the Commission may, within 30 days of the decision, appeal to the High Court. Therefore, Chair and honorable members, in an instance where the Commission refuses to investigate a matter, that is a decision that they have made. So a person who's aggrieved with that decision of the Commission to refuse to investigate a matter can go under Clause 30 of the bill and appeal to the High Court. I submit, Chair.
Okay, progress. Before we proceed, I would like to request the honorable member who's just walked in to introduce himself.
Thank you, Chair. May I start by offering my sincere apologies. I had another engagement and I hadn't been notified of this meeting until this morning.
Noted.
My name is Honorable George Chisanga. I'm MP for Lukasha constituency and a member of this committee. Thanks.
Honorable members, like I've already indicated, Minister of Justice is here to stay. So if we have other clarifications would want to seek, maybe we keep note of those. Since we still have those justice people, we can make an arrangement that before we have our first meetings tomorrow, before our first witness, we can delve into those other questions that seek clarification. Because now already you see how much time before we started, and there are some of the witness has been here for more than, so I think we have to bear with the witness also. That's my request. At this juncture, I would like to invite the... Okay, thank you very much for that. And since you are still with us, the immunity is withdrawn. I'm sure, like you are saying, there were inadequacies with the former or the previous, the current ones. Me, I would have also suggested that together with the clerk and staff, we should have had two bills here, the current one and the proposed one, so that when we are making comparisons, we are able to, like for me, I don't have the current, so that's my request anyway. So, you can stand out. Yeah. Yes.
Thank you, Chair.
So, yeah. Pardon? The immunity, it has been removed. National Prosecution Authority. You are welcome to this Committee on Legal Affairs, Governance, and Human Rights. I will proceed with introductions first, and then we'll go into the presentation of the submission. Thereafter, we shall have some interaction of questions and answers if there need be. Thereafter, the meeting comes to close. So I'd like to request the honorable members to introduce themselves.
Thank you, Chair. Good morning to the witness. My name is Tasila Lungu Mwansa. I'm Honorable Member of Parliament for Chalma constituency. Thank you.
And also the Vice Chairperson of the committee.
Good morning, witness. I'm Lamek Hamwata, Member of Parliament for Pemba constituency and a member of this committee. Thank you.
Good morning. My name is Achinga Mnyoto. I represent Karab Central, and I'm sitting in for the substantive chairperson who's attending to other national duties.
Thank you, Chair. Leonard State Council, welcome to the meeting. My name is Honorable George Kangwachisanga, of course a colleague at the bar and a member of this committee, Member of Parliament for Okasha constituency. Mr. Bako, you're welcome.
I'm Anthony Kasande, Member of Parliament for Bangul constituency. Good morning.
I'm Lenga Fuve, Member of Parliament for Chiruvi constituency and also a member for this committee. I would like to welcome our witness.
The clerk and staff.
Good morning, DPP. My name is Sanford Mwinde from the Office of the Clerk.
Justice.
Good morning, Chair and honorable members. My name is Tauna Daka. I'm Parliamentary Counsel at the Ministry of Justice.
Good morning. My name is Diana Majoko Shamabobo. I'm a Principal Parliamentary Counsel from the Ministry of Justice.
Good morning. Excuse me. Good morning, Honorable Chair, and good morning, Honorable Members. My name is Michael Mutwena. I'm a Parliamentary Counsel from the Ministry of Justice. Thank you.
Thank you. Introductions on the National Prosecution Authority.
Thank you so much, Chair and honorable members and officials from the Ministry of Justice. My name is Gilbert Piri, Director of Public Prosecutions of the Republic of Zambia. And with me here is Mr. Bako Chipalo, who is the Deputy Chief State Advocate in charge of Lusaka Province. Thank you, Chair.
Thank you. However, I can request what's one to hear his voice.
Indeed, Chair.
Thank you very much, Chair, and good morning, everyone. My name is Bako Chipola, Deputy Chief State Advocate from National Prosecution Authority in charge of Lusaka Province. Thank you.
I'm bestowing on you the immunity against any prosecution and the use of the submission you have to make today in any court of law in Zambia arising from Cap 12. However, the same Cap 12 can be used against you if it is found that you deliberately misled this committee during the interaction. But my hope and trust is that you are a major stakeholder, very reliable, that there's no way you can mislead this committee. This submission is to level the ground to enable this committee achieve and proceed effectively. At this juncture, I'm sure our interaction today, you are much aware of what is the